Thank you very much for joining us on the program. We begin in the Democratic Republic of Congo, DRC, where around 31 candidates from the last legislative elections have appeared in court in what they call a fight for their mandate. It comes after the MP's election win was since rendered invalidated by the judgment of a special high court in the large Central African country. The decision, the court said, was for its special chamber to correct material errors in the December 30 election. On Tuesday, the MP candidates arrived at the Constitutional Court where election petition matters were examined by the lawyers.
Exactly, Jerry. These candidates are claiming their right to sit in the National Assembly. To their defense, the Article 168 of the Constitution stipulates that the judgments of the Constitutional Court are neither retractable nor reformable, and that, consequently, their mandate validated at first instance cannot be invalidated. To discuss this further, we are joined by Louis Do Balekalai, spokesman of the FCC Cash Coalition from Kinshasa in the DRC. Mr. Balekalai, thank you for joining with us this morning. The 31 MPs of FCC Cash invalidated by the ruling of the Special Chamber of the High Court have since on Tuesday been on meetings with government institutions. What is the meaning of this approach? The strategy here, first of all, is to show Congolese people and the international community that for the first time in the history of the Democratic Republic of Congo, a panel of judges willingly and shamelessly violated the Constitution by contradicting the decisions they made previously to confirm a group of MPs in May and June. This is contrary to the Article 168 of the Constitution of the Democratic Republic of Congo, which states that judgments by the Constitutional Court are enforceable to all persons and are not subject to appeal. The article further advocates for the binding nature of the judgments on everyone, including the judges themselves. Therefore, despite any previous legal actions, we consider that those of us that had been approved before these recent new rulings deserve to sit in the next session of the National Assembly, and that nobody can prevent us from doing so.
Nous considérons que nous qui avons été validés avant ceux qui l'ont été au terme des derniers arrêts, nous méritons de siéger à la session prochaine à l'Assemblée nationale et personne ne pourra nous en empêcher.
So you met the chief of staff of the court and not the president, the court president himself. Can we know why you chose to meet with the chief of staff instead?
The president of the Constitutional Court was unavailable, so we gave our memo to his chief of staff. We also handed over our memo to the presidency of the Republic. Then we headed to the National Assembly, where we were received at the highest level by the special advisor to the head of state on security. We submitted our memo and declared our rights before asking for everyone's involvement to prevent things from getting worse, following the unscrupulous conduct. And I would like to mention in passing that we have lodged a complaint against the magistrate who presided over the special chamber, which made the radical error in passing the judgment to nullify a group of Lamuka MPs. Our aim is not to validate them, but rather to advocate for the prior legal actions to be upheld, i.e. we have sat down. If there is a solution for others that have been validated after us, it is up to the institutions, the Constitutional Court and the National Assembly to find a political solution. A while ago, it was the invalidated opposition members who were standing up against the court, and now it's you. Are we not heading towards an impasse? There is no impasse since the Constitutional Court's ruling cannot revoke another ruling. That is a fact, and that we'll have to understand. Rulings from different courts may be repealed, but in this case, the legal decisions were made by the same institution in a contradictory manner. This is a serious and historic misconduct that will forever weigh on the shoulders of the magistrates.
So what are your current plans? Have you got any plans to brave the odds to sit at the National Assembly?
I will attend with other colleagues. We will sit for this and the next sessions. It's an obligation to my constituents. They will accompany me to the chamber and I will sit in. We have our court ruling that validates us as elected members of parliament, and so we are entitled to sit in the National Assembly. It is a legal act that cannot be revoked by another judgment of the same court, and therefore it is up to the Constitutional Court and the judges who will forever be held historically accountable to the nation by citizen and international community.